our topic today is moving with your child, what every parent should know about the law. So I'll just jump right into it. And to mention that the topics that we will be covering under that heading would be the requirements for divorced and separated parents who wish to move or relocate with a child under the Divorce Act and the Children's Law Reform Act. We will also look at the new definition of relocation, which has been included in the Divorce Act and the Children's Law Reform Act. And we will look at details on the notice that must be provided if parents wish to relocate with their child or without their child. Now, in family law proceedings, two of the most litigated issues are that of parenting and decision-making as it relates to children. Under the old Divorce Act, these issues were referred to as custody and access. The new Divorce Act has replaced custody with decision-making and access with parenting time. So basically the names of those things have changed. Needless to say, in order for parents to exercise parenting and decision-making with children, there must be some proximity between the residences of both parents. Now, this will obviously become a challenge when either parent decides to relocate, as relocation quite often affects the parenting time and decision-making role of the other parent. And this is what we refer to in family law as mobility issues, and it's also referred to as relocation. Now, the term mobility and relocation can be used interchangeably when discussing this issue. So both the Divorce Act and the Children's Law Reform Act provide guidelines that should determine how the process of relocation should occur. Where parents cannot agree on relocation, the court will step in and make an order either permitting such relocation or preventing the relocation. In my presentation today, I will begin by discussing the definition of relocation under the Divorce Act and under the Children's Law Reform Act. I will then outline the requirements for relocation and then discuss how the court makes its decision in the event that the issue is brought before the court. So let's look at what is relocation. How do we define relocation? Under Section 16(8) of the Divorce Act, sorry, I jumped to my wrong slide. So relocation is defined as a change in the place of residence of a child of the marriage or a person who has parenting time or decision-making responsibility or who has a pending application for a parenting order that is likely to have a significant impact on the child's relationship with a person who has parenting time, decision-making responsibility, or an application for a parenting order in respect of that child pending, or B, a person who has contact with the child under a contact order. Now, let me jump into that because I think it sounds a little bit complicated. So relocation is a change of residence, but it's not a change of residence that will not impact parenting time with another parent. For it to be defined as relocation, it has to be a change of residence that will impact the parenting time of another person or of another parent, or it will impact the decision-making or contact with another person. So as such, it should be noted that the Act makes a distinction between simple change of residence and relocation. So let's look at what is not considered a relocation. A relocation is not a change in residence that does not significantly impact a child's relationship with the other person who has parenting time or who has contact. So it's a change of residence is not a relocation if there will be no impact on the parenting time. So under Section 16(8) of the Divorce Act, it simply reads that a person who has parenting time or decision-making responsibility in respect of a child of the marriage and who intends to change their place of residence or that of the child shall notify any other person who has parenting time, decision-making responsibility, or contact under a contact order. So let's say, for example, both parents reside in Pickering and one parent decides to change their residence to another location in Pickering or to a location around the area of Pickering. That is a change in residence. It's not a relocation. There is a requirement for notice, but the requirement for notice is not as detailed as the notice requirement that is necessary under a relocation. So although our talk is on relocation, it's important to notice, to realize that change of residence also requires the giving of notice. Given the definition of relocation, it is seen that the main distinction then is that relocation brings about an impact, a significant impact on the child's relationship with another person who has parenting time or decision-making responsibility or contact with the child. As such, in the event of a relocation, the Act provides specific guidelines for parents, and those guidelines relate to the notice that should be given by the moving party to the other party. So we'll now take a look at the notice that should be given prior to relocation. Before March 2021, the old Divorce Act provided that an order for custody may include an order that in the event the custodial parent needed to change residence, they needed to give 30 days notice to the other parent. Either parent then had a right to bring an application before the court to vary an existing court custody order. The non-moving parent could apply for custody of the child, and the moving parent would apply for permission to move. In both cases, the decision rested upon whether or not there has been a material change in the circumstances such that the best interest of the child would be affected. And when we speak of material change, it simply means that a change that is significant, it's so significant that the needs of the child will be affected. It could be a change whereby one parent becomes extremely ill and so will not be able to take care of the child. It could be a change where one parent needs to remove from that location, but it's not just an ordinary change. It has to be a significant change. The old Act did not outline details of the requirement for moving, and the courts by and large based relocation or mobility decisions on the landmark case of Gordon and Gortz, which was decided by the Supreme Court of Canada in 1996. So I will take a brief look at that case just to give an idea of how the court decided issues of relocation prior to March 2021. Now, in Gordon and Gortz, the parties divorced in 1990, and the mother was given custody and primary residence of the child. The father had generous access. Upon learning that the mother planned to move to Australia to study orthodontics, the father applied for custody, and he applied for two things. He sought alternate orders from the court. On the one hand, he asked for custody, and in case he did not get custody, he sought an order that the mother should be restrained or prevented from moving with the child. Now, in that case, the trial judge, which was the first step in the litigation process, which was the Superior Court, that judge ordered that the mother should be allowed to move to Australia, and that court varied the access order to allow the father to have access in Australia. Now, from the Superior Court, there was an appeal that went to the Saskatoon Court of Appeal. This was a case that was determined in Saskatchewan. So at the Saskatoon Court of Appeal, again, the decision was upheld, and mom was allowed to move to Australia, and dad could exercise access in Australia. The court went to a higher court, which is the highest court in Canada, and that's the Supreme Court of Canada. And that court partly upheld the decision, allowed mom to move, but varied the decision slightly and allowed dad to have access in Canada. which meant that mom had to facilitate the child coming back to Canada so that that child could have some parenting time with dad. Now, in arriving at its decision, the court relied heavily on what was paramount, which was the best interest of the child. The court also referred to the need for the child to have maximum contact with both parents. But we must note that even though there is a principle in family law, which is called the maximum contact principle, meaning that children should, as far as possible, have maximum contact with both parents, it is not an absolute principle. And that principle has to be balanced against a child's physical, emotional, social, and economic needs, and in light of the quality of his or her relationship with both parents. In other words, even though there's a maximum contact principle is important, if it will be harmful to the child to have maximum contact with both parents, then the court will not apply the maximum contact principle. But in this case, the court applied the maximum contact principle, but the court also looked at other issues. And the court embarked on a two-stage process in order to determine whether they should allow the relocation. The first stage that the court looked at was whether there had been a material change in the circumstances since the original parenting order was made. Now, in determining whether there had been a material change, the court looked at whether there was a change in the ability of the parents to meet the needs of the child, whether that change materially affected the child, and whether that change could have been foreseen at the time the original order was made, or whether the change was reasonably foreseeable. And this is what the court referred to as a threshold test, meaning that that's the test that they start out with. Now, once the court decided that there had been a material change, the court went on to the second stage of the assessment. And we can say that that's the most important stage, because the second stage involved determining what would be in the best interest of the child. So, in determining the best interest of the child, the court looked at various factors. And those factors included looking at the existing custody arrangement and the relationship between the child and the custodial parent, looking at the existing access arrangement and the relationship between the child and the access parent, looking at the desirability of maximizing contact between the child and both parents, looking at the views of the child, and I should point out here that looking at the views of the child is dependent on the age of the child, because obviously if a child is 5 years old, that the views of that child will not have as much weight as the views of a child who is 10 or 11 years old. But the court will take that into consideration. In determining the best interest of the child, the court will also look at the custodial parent's reason for moving. They would look at the disruption that move will bring to the child, disruption in the change in custody. And the court will also look at disruption to the child in terms of removal from family, from schools, and from the community that the child has come to know. So those are issues that the court will look at in determining what would be in the best interest of the child. Now, once the applicant shows that there has been or is likely to be a material change, then both persons have the duty to convince the court of their case. They have the burden of proof, and I'll explain what that means. Now, if parent A, the moving parent A, is alleging that it will be in the best interest of the child to move, then that parent has the duty of convincing the court that that is what should happen. Now, if parent B, which is the parent who is not moving, is trying to convince the court that it will not be in the best interest of the child to move to a new location, the burden of proving that would be on that parent. So burden of proof is something that came out. It was not a part of the old legislation, but it was mentioned in the case of Gordon and Gertz. And so that in that case, the judge said both parents had the burden of proof, meaning that both parents had to convince the court equally of the case that they wanted the court to decide on. They had to convince the court either that it was best for the child to remove from the jurisdiction or that it was better for the child to remain in the jurisdiction. Okay, let's look at the changes in the legislation since March 2001. Now, what I just referred to before would have been the Gordon and Gore's, the case law, and I also referred to the legislation that existed before March 2021. So the new Divorce Act came into being in March of this year, 2021. The Children's Law Reform Act also was revised in March and April this year. What the new legislation did basically was to take issues from the leading case, the landmark case, Gordon and Gore's, and they made it a part of the legislation. And they also made certain modifications, and they expanded the requirements that had to be followed in terms of parents who wanted to relocate. Now, one important aspect of the new act is that the term custody, as I mentioned earlier, the term custody has been replaced with the term decision-making role. So we no longer use the word custody, we use the words decision-making role or decision-making authority, so that a parent can either have sole decision-making authority or they can have joint decision-making authority with each other. The new legislation also changed the term access to parenting time. So rather than speak of access, we now speak of parenting time. And again, parties can either have equal parenting time or one party can have more parenting time than the other party. Now, in relation to mobility issues or relocation, the new act also starts out by giving a clear definition of what is meant by relocation. And I did mention earlier in the presentation how relocation is defined. So having outlined basically what the new act does, we will go into more detail of the new legislation, which would be both the Divorce Act and the Children's Law Reform Act. And we'll now talk about the requirements for relocation. And one of the main requirements would be the notice that has to be given. So let's start by looking at Section 69 of the Divorce Act. When should notice be given? Now that section, I'll read the section. It says, a person who has parenting time or decision-making responsibility in respect of a child of the marriage and who intends to undertake a relocation shall notify at least 60 days before the expected date of the proposed relocation, and in the form prescribed by the regulation, any other person who has parenting time, decision-making responsibility, or contact under a contact order in respect of that child of their intention to move. So it's important to notice that previously there was a 30-day requirement. Now there is a 60-day requirement to give notice to the other side if there's an intention to move. And what's important to note as well is that it's not only the other parent that has to be notified. Sometimes the court makes contact orders in respect of children. A grandparent, for instance, or a relative may move to the court and ask the court to make an order that allows them to have contact with that child, even though that person is not the parent. That person also needs to receive the 60-day notice. So in terms of who should, in terms of giving out the notice, it will be given to the other parent as well as anyone who has contact with that child. What should be in that notice? The notice should, there's a prescribed form that we will share with you, and that is available on the government website. But basically, the notice should stipulate the expected date of relocation, It should stipulate the address of the new place of residence and the contact information of the person or child, as the case may be. The notice also should stipulate a proposal as to how parenting time, decision-making responsibility, or contact, as the case may be, could be exercised. Because obviously, if parent A is the parent who will be moving, the parent A will be the parent who will be moving, that parent should suggest to the other parent, well, I'm moving, let's say parent A is moving from Pickering to Windsor. Parent A should be the one to suggest to the other parent or to the other party, this is how I will facilitate parenting time taking place. This is how I will facilitate decision-making responsibility. So it's up to the moving parent to put forward a proposal so that the parent who is not moving will not be robbed of their parenting time or of their responsibility in terms of decision-making or in terms of contact. The notice should also include any other information that is prescribed by the regulation. So the 60 days notice, the reason why the legislation stipulates 60 days is because it provides an ample opportunity for the non-moving parent or anyone with a contact order to bring in an application before the court to have the existing parenting order revised or varied. Who needs to receive the notice? As we said before, the other parent, of course, as well as any person who has a contact order. Now, it should be pointed out that in many family law cases, and I know some persons may be wondering about this, in many cases, there are issues related to family violence, which may make it dangerous for one parent to notify the other of his or her new address. Now, the legislation takes this into consideration and has made provision for the moving party to approach the court and apply for an order dispensing with the requirement to give notice. And this will include situations where there has been past incidents of family violence or threats of violence. So even though there's a requirement for notice, there are exceptions to the giving of notice. It has to be a case where there has been family violence. And more than likely, once there's the party who has gone to the court has convinced the court of the threats of violence, then more than likely the court will dispense with the need to give that notice. Now, what happens once notice is given to the other party or parties? The party who receives notice has 30 days to respond, either by sending a notice objecting to the move or by bringing an application before the court seeking either parenting time and decision-making responsibility of the child or seeking a variation of an existing parenting order. Now, in an application before the court, the party who received notice may also seek an order preventing the other parent from relocating with the child or children. And Section 39.3 of the Children Law Reform Act has the same provision as the Divorce Act. So what we will do now is to have a quick look at the format of the notice. And as I said, this notice is available on the government website. So if we look at the notice, this is a notice of relocation. Part A, in Part A, you should state your name and your current address, phone number, current email address. And then in Part B, you give information about the relocation. You choose one of these. You either choose whether you're planning to relocate with the child or with the children, or you choose whether you're planning to relocate. Sorry, the first option there, are you planning to relocate without the child or the children, or whether you're planning to relocate with the child or children, or whether you're planning to relocate only the child or children and not yourself. So that information will be provided in Part B. Then below that, you list the name, if it's one child, two children, there's space there for a number of children. And obviously, if there's no more space, you use another sheet of paper and you provide information of the children, which child you're relocating with, which child will be relocated, and what have you. There is also a form that can be used to give the notice, the 30-day notice, objecting to relocation. Again, that's available on the website. Now, it should be noted, if you move on to the next slide, it should be noted that you've heard me mention the Divorce Act and you've heard me mention the Children's Law Reform Act. So just to explain a bit more on that, the Divorce Act relates to persons who are married or who were previously married. And it's a federal legislation, meaning that it applies throughout Canada because divorce is something that is governed by the federal government. In every province, the provisions of the Divorce Act would be the same. But the Children's Law Reform Act relate to parties who have children, but they are not or have not been married to each other. Now, the Children's Law Reform Act is a provincial legislation, which means that it applies only in Ontario. Now, the other provinces have similar legislation, called by different names, of course, but they also have their provincial legislation that relate to families where parties have not taken part in a registered in a marriage. So, however, even though these are two different pieces of legislation, in terms of relocation and in terms of how the court determines what is in the best interest of the child, they mirror each other in that they have the same provisions. So the parties who come under the Children's Law Reform Act will not be disadvantaged in any way because they cannot operate under the Divorce Act. The two pieces of legislation have similar provisions. So how does the court decide? Once we go before the court, the notices have been given, there might have been some objection, and it's likely that the matter goes before the court because one party will not support the relocation of the children or of the other party. So how will the court decide? Now, I mentioned earlier the case of Gordon and Gortz. Now, this is still the leading case on mobility, but the new legislation has brought about some changes, and this will affect somewhat how the court will decide from March 2021 onwards. Now, while Gordon and Gortz outlined a two-part test that started with the need to determine whether there has been a material change, if you recall, I referred to material change in circumstances, both the new Children's Law Reform Act in Section 29.2 and the Divorce Act in Section 17.5.2, they both state that relocation in itself consists of a material change in circumstances, unless the court had prohibited relocation in the original parenting order. So because the legislation stipulates that moving is considered a change in circumstance, the court will not have to go through that process of assessing whether there has been a material change in circumstances. What the court will do would simply jump into the determination of what is in the best interest of the child. And there was the provision earlier of determining how to determine the best interest of the child. That has changed slightly with the new legislation. And if you look at Section 24 of the Children's Law Reform Act, we will see that the court looks at various factors again in determining what is in the best interest of the child. And those factors are the child's needs. And the needs of the child will be determined based on the child's age, the child's stage of development, such as the child's need for stability. For instance, a child may be 5 years old. He has different needs from a child who is 10 years old. Apart from that, a child may be 10 years old, but may have a mental or physical disability. So those needs will be different from a 10-year-old child that has no physical or mental challenges. So in assessing the needs of the child, the court will take into consideration the age, the mental stability, physical development of the child, and make a determination from that basis. Apart from the needs of the child, the courts will also look at the nature and the strength of the child's relationship with each spouse, and also with each of the child's siblings and grandparents and any other person who plays an important role in the child's life. For instance, there may be a parent who hardly exercises his parenting time. He may see the child once in every 6 months, maybe once in every 8 months. There may be no relationship with the grandparents. So if the moving parent decides to relocate, obviously the fact that the non-moving parent has a very weak relationship with the child, the court will take that into consideration in assessing the needs of the child, because that child will not be losing anything by relocating to another residence. The other factor that the court will look at in determining the needs of the child would be each spouse's willingness to support the development and the maintenance of the child's relationship with the other spouse. Now, on that factor, I can tell you that if two parents live within close proximity of each other, and the parent who has the primary residence of that child continuously makes it difficult for the other parent to maintain a relationship with that child, then if the moving parent, the parent who has primary residence, if that parent decides to move, the fact that parenting had been interfered with previously, the court will take that into consideration, because if you live in close proximity of each other and parenting is being hampered, that is likely to increase if parties move far apart from each other. So that will be a factor that the court will take a close look at. The court will look at the history of the care of the child. Who has been doing certain things for the child? Who's been taking the child to school? Who has been taking the child to their medical appointments? Things like that. The court will look at the child's views and preferences. Again, it depends on the age. This will be affected by the age of the child and the maturity of the child. Some 10-year-olds may be more mature than other 10-year-olds. So the court looks at those various factors. The court will also look at the child's cultural, linguistic, religious, and spiritual upbringing and heritage, including indigenous upbringing and heritage. The court will look at any plans for the child's care. So on this factor, what I would suggest is that the moving party should have a plan for the care of the child. Also, the non-moving party. If the non-moving party is trying to have the court vary the parenting order so that the child will now move to reside with the party who's not moving, that party should have a plan for the care of the child. That plan may outline what school the child will attend, who the child will come into contact with on a daily basis, what plans will be made for extracurricular activities, what plans will be made to visit the other parent, visit extended family. So a plan of care will be helpful in helping the court to determine whether the move will be in the best interest of the child or whether remaining behind will be in the best interest of the child. Another factor that the court will look at is the ability and willingness of each party in respect of whom the order would apply to care for the child and to meet the needs of the child. Obviously, there will be no point in leaving the child behind with the other parent if that parent doesn't have the willingness to take care of the child on a daily basis. So the court will look at that factor. The court will also look at the ability and willingness of each person in respect of whom the order would apply to communicate and cooperate in particular with one another on matters affecting the child. What relationship, the relationship that parties have with each other, how will that affect the child, and how will that play out if the child is relocated to another part? So that is what that factor really boils down to. The court will also look at whether there has been any existence of family violence and how that family violence will impact on, among other things, the ability and willingness of any person who engaged in the family violence to take care of and meet the needs of the child. And two, the appropriateness of making an order that would require persons in respect of whom the order would apply to cooperate in issues affecting the child. And the court will also look at any civil or criminal proceedings that are currently in existence as it relates to the parent. Now, I mentioned family violence as one of the things that the court will look at in determining what's best for the child. Now, the legislation has said that the court should pay attention to the nature and seriousness and frequency of the violence. Now, violence, not all violence are the same. Some violence will affect the child in a negative way and some will not. And so we cannot say that because there has been family violence, definitely the court will not make an order in relation in support of that parent who committed the violence. It depends on various factors. And some of those factors include the nature, seriousness, and frequency of the family violence, when it occurred, and also whether there is a pattern of coercive and controlling behavior in relation to the family member. In other words, a one-off act of violence may not be very persuasive in court. The court will also look at whether the family violence is directed towards the child or whether the child is directly or indirectly exposed to the family violence. The court will also look at the physical, emotional, and psychological harm or risk of harm to the child, any compromise to the safety of the child or any other family member, whether the family violence causes the child or other family member to fear for their own safety or for that of another person, and any steps taken by the person engaging in family violence to prevent further family violence from occurring and improve their ability to care for and to meet the needs of the child and any other relevant factor. In other words, in relation to G, parent A may have committed some form of violence, but parent A has since attended anger management classes or parenting classes and has taken serious steps to deal with the violence that they may have committed. That will impact the court. That will affect the decision that the court will make in terms of what is best for the child. Also, it should be remembered that violence is not only physical. Under family violence is included financial violence. And in most cases, that may not have it may have a serious impact on the child, but it's a factor that the courts will consider as against physical violence, because there's physical violence, there's mental violence, there's financial violence. So based on the type of the violence that existed, the length of the violence, the reoccurrence of it, and how it impacted the child, the court will make a determination in each particular case. Apart from assessing the best interests of the child in determining whether or not to order a relocation, the court will look at a few other factors. The reason for the relocation. Some parents relocate just to spite the other party. The court will look at that. It has to be a genuine need for relocation, not just your whim and fancy. It has to be genuine. And the court will look at the impact of the relocation on that child. The court will also look at the amount of time spent with the child by each person who has parenting time or is an applicant for a parenting order with respect to the child. Now, some of these overlap with the original factors highlighted in determining the needs or determining what's in the best interest of the child. Another factor the court will look at is whether the person who intends to relocate has complied with any applicable notice requirement under the Section 39.3 or Section 39.3 refers to the Children's Law Reform Act, or under Section 16 of the Divorce Act. So you must comply with that 60-day notice requirement, because the court will try to determine whether that has been complied with. The court will also look at the existence of an order, a family arbitration award or agreement that specifies the geographic area in which the child is to reside. Because sometimes, originally when parties would have gone to court and there might have been a parenting order or an order related to decision making, in that order the court may have stipulated that neither party, for instance, neither party shall remove the child from the city of Toronto without further court order or without the consent of the other party. So parties are restricted as to where they can take the child. Or it could be that neither party shall remove the child from the region of Durham unless there's further court order or unless there's the consent of the other party. So the court will look at any existing order to determine whether there's a restriction on moving. It does not mean that the court will not vary that existing order, but the court will take a look at that order to see if there's a restriction in terms of the geographic area within which the child shall reside. The court will also look at the reasonableness of the proposal of the person who intends to relocate the child to vary the exercise of decision-making, responsibility, parenting time, or contact, taking into consideration other things, the location of the new residence. So for instance, if parent A is the parent who is relocating, it is expected that parent A will put forward proposals to allow the remaining parent to exercise parenting time. The court will look at the reasonableness of that proposal. Now, if parent A sends in a proposal such that, oh, you will have a chance to see this child for 1 week in December, and that's it, that is not reasonable. And the court will take that into consideration and will make an order based on that, because parties need to be reasonable in exercising parenting. A more reasonable suggestion might be twice per year, depending on where parties are relocating to. If they're relocating outside of Canada, it may be twice a year, or whatever the case may be. If it's within Canada, then there may be more a proposal that involves more frequent instances for the other party to exercise parenting time. But the court will look at that proposal and determine whether it's reasonable. So it's important that parties should be reasonable in their proposal. The court will also look at whether each person who has decision-making responsibility or parenting time, or is an applicant for a parenting order with respect to the child, has complied with their obligations under any applicable act, regulation, order, arbitration, or and the reason why the court will look at that, because if there's an existing order whereby parties live in close proximity of each other and that order is not being obeyed, then that gives an indication to the court that if you move further away, it is unlikely that you will obey any order that the court makes for parenting time. So it's important that if there's an existing order, parties should obey that order, because it will impact any future decision that the court can make on their behalf. So let's move on, and we'll look at, I did mention earlier something called burden of proof, and I did explain what the burden of proof is. It relates simply to who has to do the convincing to the court, who has the duty to convince the court either to permit the relocation or to prevent the relocation. Now, before March 2021, neither the Divorce Act nor the Children's Law Reform Act specified who had the burden of proof. Now, in the case that we mentioned, Gordon and Gortz, that case does mention burden of proof and states that both parents have the burden of proving to the court what is in the best interest of the child. The new legislation implemented the burden of proof. It was not mentioned in the old legislation. So the new legislation has implemented it, but they've changed the requirements from what was stated in Gordon and Gortz. And this is how the legislation says it. It says, if the parties to the proceeding substantially comply with an order, and I want you to take note of that first part, because the court is very serious about complying with existing order. Because if you're not complying with an existing order, you will be viewed in a very negative light if you go before the court. So it says, if the party to the proceeding substantially comply with an order, an arbitral award, or an agreement that provides that the child of the marriage should spend substantially equal time in the care of each party, then the party who intends to relocate the child has the burden of proving that the relocation would be in the best interest of the child. So I'll break that down for you in a little bit. What that section is saying, because just to back up a bit, when parenting orders are made, there are different types of parenting orders. There can be an order that allocates equal parenting time between the parties. Mom may have 50% and dad may have 50%. And that can take a form of 1 week with mom, 1 week with dad, or it can take another form. But basically, parenting time is 50-50. Decision-making is joint decision-making. In such a case where you have that type of equal parenting, then the party who wants to relocate with the child or relocate, that party has the burden, has the duty to convince the court that relocating would be in the best interest of the child. But let's look at another scenario where one party has more time with the child, where the primary residence of the child is with only one party. And Section 16932 of the Divorce Act says, it starts off again with if the parties to the proceeding substantially comply with an existing order. And then it goes on to say, if the agreement or the court order provides that a child of the marriage spends a vast majority of their time in the care of the party who intends to relocate the child, then the party opposing the relocation has the burden of proving that the relocation would not be in the best interest of the child. In other words, let's say dad has the child only every other weekend. Mom has the child every other time. So the child basically resides with mom and the child sees dad every other weekend and maybe one day during the week. So the child spends the majority of their time with mom. So if mom wishes to relocate, dad has the duty to convince the court that relocating with the child or mom relocating will not be in the best interest of the child. So it depends. It seems, let's go on to the other cases where none of that exists. So in every other case, the parties to the proceeding have the burden of proving whether the relocation is in the best interest of the child or whether it's not in the best interest of the child. So what it seems like is that parties who do not have primary care of the child, parties who see the child perhaps every other weekend, less frequently than the other party, they may have a more difficult time in convincing the court not to permit the relocation of the child. I'll look at one recent case just as an example of how this was decided. And bearing in mind that this new legislation came out in March 2021, there aren't a lot of cases that would have been decided on the issue since then. But there's one case decided on September 3rd in Alberta, and it was decided by the Alberta Queen's Bench Division, and that's the case of LMS versus CES. LMS, who's the mom, has had the majority of the parenting time with the children since separation. LMS wanted to relocate to California with the children. LES, who's the dad, objected to the relocation and asked that the children should reside with him if LMS insisted in moving. Although the court found that LMS had not provided convincing reasons to justify her move, the court still found in her favor and allowed her to move to California. And what was the reason why the court found in her favor? Remember, the children spent most of the time with her. So even though she was not very convincing, the dad had the burden of proving to the court that moving will not be in the best interest of the child. Now, in his case, he did not prove that to the court. And because he did not prove that it will not be in the best interest of the child, the court allowed mom to move with the children, even though her reasons for moving were not convincing. Let's look at another case, and this is the case of Siddiqui versus Khan, and this one was decided in August. In this case, mom had custody and primary care, and she had primary care of the daughter, and dad could visit the daughter twice per month, which would amount to every other weekend. Mom wanted to move to Dubai for 1 year to teach. Dad objected and claimed that such a move would damage his relationship with his daughter. The court considered what would be in the best interest of the child and accepted the fact that 1 year in Dubai will present a unique opportunity which would benefit the child. By virtue of Section 16.932 of the Divorce Act, the father had the burden of proving that the relocation would not be in the best interest of the child. Remember, mom had more time with the child. Child spent most of her time with mom. And so because of that, dad had to prove that this relocation will not be beneficial for the child. The father was unable to discharge his burden. He was unable to prove to the court that the relocation would not be in the best interest of the child. In fact, the court found that moving to Dubai, would be beneficial. So based on these two cases, and we have to keep our eyes out for other cases that will be decided under this new legislation. But it seems fair to conclude that if you're a parent that has less time with the child, then you have a harder task of convincing the court that moving will not be in the best interest of the child. So assuming that this matter has gone to court, the court has found in favor of the moving party, the court allows mom to move, or the court allows dad to move, as the case may be, because oftentimes it's dad may have primary care of the child and dad may want to move. So assuming that the court permits the relocation, what happens then? Now, the court has the power to apportion the cost that will be incurred for the non-moving party to exercise their parenting time. So let's say, for instance, mom, in the case of Siddiqui and Khan, let's assume that mom has moved to Dubai. Dad has to exercise his parenting in Dubai, or maybe the child will come to Canada. There's a cost that will be incurred. The court has the power to apportion costs, and the court can do it in various ways. The court may say, okay, the cost of a ticket may be 1,000 Canadian dollars. Each party will contribute $500. Now, it's not an absolute that the court will apportion costs. The legislation says the court may apportion costs, and it depends on the circumstance of each case. The court will also obviously look at the means of each party. And so based on the means of each party, based on the particular circumstance, the court may determine to apportion costs. There may be cases where the court may determine that if dad has to pay $1,200 in child support, the court may decide that perhaps the amount of child support can be reduced. Whatever it takes to apportion the cost, the court may apportion costs to offset the exercise of parenting time. So in conclusion, I'll just highlight the main points of the presentation. The first point is that relocation is defined as a change of residence that will impact the parenting time and contact with another person. Change of residence is simply a move that does not create such an impact. So there's a distinction. Simple change of residence that does not create an impact, and change of residence that creates an impact on parenting time, which will be termed relocation. Now, in both situations, notice is required, but for a relocation, 60 days notice is required. The notice there's certain specific requirements for the contents of the notice. There must be a response provided within 30 days. If the matter goes before the court will make a determination based on what is in the best interest of the child. And the court will also take additional factors into consideration, such as the reason for the relocation, the impact of the relocation on the child, and the court also has the power to apportion the cost of parenting time, exercising parenting time between the parties. Thank you.